discussion, as well as Alex Afenyo-Markin, who is MP for F2. We're grateful, gentlemen, for your time.
Thank you very much.
Two legal brains that help say situation pretty well. Just to remind you as well that this is an electronic version of what's happening. That's how come we're switching their TV sets. It's been eventful. It's been very eventful. Before I start, I don't know what generally your views have been as far as what's happening in court is concerned.
You want to start with me?
Yes.
Very well. And good afternoon to your wonderful viewers. I think that it's been eventful, but not eventful. And I'll tell you why it's been eventful. It's been eventful because Mr. Chikata has proved beyond all doubt that he's an able counsel, and he has asked all the necessary questions. But it's also not been terribly eventful because in the course of his cross-examination, there hasn't been much objections from the other side, meaning he's been working very well within the rules and procedures, and that nobody has had any reason to challenge any of the questions he has asked so far. But so far, so good. As far as I am concerned, the case is progressing. It's rather slow, even in spite of the methods they have devised to quicken the pace. It's slow, but I can very well understand. You put before any court 11,000 documents. They have to be examined, possibly one by one. And I'm sure that is what is going on.
Honorable, yes. Afternoon to you, a very good one.
Thank you.
And your viewers who are glued.
Is it an electronic afternoon or manual one?
Both of them. And good afternoon to my very learned singer and uncle Kakasama. Anyway, I think so far so good, in my opinion. Dr. Baumia still remains firm. He is really going through very technical questions. Like he indicated earlier, this is all about procedures. You can be telling the truth in the witness box, but you can also contradict yourself depending on how you respond to a particular question. There are a lot of questions that are being asked that to me are real technical traps, but he seemed to have done his best in surviving them. You could also see that because we've had two lawyers, coming before Mr. Chikata, he was supposed to come up with really something new instead of repeating, old questions that have already been asked. And if you look at the way yesterday when he started, this morning I had the opportunity to comment, and I said, it was not as impressive as I expected yesterday. But if you ask of my view this afternoon, I would say that he's asked very fundamental questions, very, very technical questions. Yes, today.
He said a lot of traps.
Yes, and the questions he's asked are very technical. And I think for lawyers, we've all got something to learn from. I don't want to give the political bit of it. So let's see how the next phase would go.
And indeed they'll come back at 1:45. We'll take a look at that. Before we continue, I just need to draw our attention to the fact that this case is quite related to what's going on. That's a case that Bernard Mona took to court in relation to whether the hearings can go on even on public holidays. That's the hearings that we're seeing. And then as well, whether there could be a review of a sort, just in case that whoever wins or loses not too happy about it. Those were issues put into the CI, and then initially were not to have public holidays. They could sit on public holidays, and there was no room for a review of a sort. It's just been pronounced by the Supreme Court that has been struck out, so they cannot sit on public holidays, and they as well will be compelled to give a review. So that's, as far as this case is connected, is related to this case pretty well. So these are facts that will obviously go to affect what's the case, the outcome of the case.
It's an interesting judgment, and what it means is that whoever loses may try to apply for a review.
Yeah.
Two issues will arise. The first one is assuming that Nana Akufo-Addo wins, and then President Mahama applies for a review. Under the general law, a review does not operate as a stay of execution. What happens? Does he resign during the pendency of the review application, or he stays in office during the pendency of the review application? My understanding from precedent is that whenever there's a review, there's a gentleman's agreement. The ruling is not enforced until after the review application has been taken.
Remains.
Yeah, the status quo remains. The other issue is that, assuming that the judgment that comes out finally is unanimous, a review will be pointless because only 2 judges will be added, and most of the time what
unanimous,
happens,
that is
say 9-0 against this man or that man.
Is this possible?
Why not? It's quite possible.
Okay.
Yes, so in that case a review will be pointless.
So it means that even should you add 2, you expect
it is most unlikely
to against 2,
yes,
or 10 against 2.
Exactly.
It's unlikely that any of the 9
will change their minds. Yeah. Okay. So that is the issue that will arise. But it's good. We are learning as lawyers, also as citizens of this country, how we should deal with our own democratic principles. And I am happy that this is going on smoothly. The only trouble, as I indicated last week Tuesday, is that productivity has been affected by this case. And I find it extremely unnerving. I hope we never ever go through this again.
Well, there are those who also argue that
productivity against stability.
Try the option. The other option, okay, yeah.
Yes, productivity against.
I would want you to maybe in addition to the point
yes,
in terms
clearly,
of what the effect that this ruling is going to have on the case at hand.
Really, the only effect is the opportunity to make an appeal. Okay, just as you indicated, the issue of a review operating as a stay is not founded in any of our law books. He said there is always a gentleman's agreement. Now look, I'm seeking a review, and for that matter, you stay execution. But this is a political case. The stakes are high. So I think it has to do with the interpretation of the Constitution. That yes, like I'll follow the example he cited, because that's what is likely to bring some controversy. Because if Mr. Mahama wins, His Excellency the President, I mean, he will be there, the status quo remains. But the question is that now that there is a review, if Bernardo wins the case and NDC and President Mahama decide to appeal, and say EC decides not to seek review, what happens? Immediately, the point here is that look, once the Supreme Court makes that declaration, the man ceases to be president. It's clear. As to applying for a review is another matter. We have the Speaker of Parliament who acts as president in the absence of the president and the vice president.
So you'd rather he should step aside?
No, it's not. It's not such time. No, it's not me. No, I mean that's. I think. Well, let's pick it for. It's an electoral commission that declared you a winner of an election. Okay. You didn't declare yourself.
Sure.
Now, the electoral commission, its conduct is subject to a legal, a determination, and the Supreme Court now says that what the electoral commission did was wrong in law. You are bound by it. It's not a matter of saying that I am seeking review of that decision, so I want to still remain in office. That is not possible. That is why I brought in the issue of...
You cannot file a stay of execution here?
No. The Constitution, if it says that you are not the President of the Republic, you are not the President of the Republic.
As per judgments by a competent...
That is nullifying a declaration by an administrative body.
Yes.
Okay.
So can't you file a stay of execution while you seek the review?
What I'm saying is that the Constitution makes provision for a body and an institution of Parliament headed by the speaker to act as a president, so that there will be no vacuum. So if you are seeking review, bear in mind we are talking about political stability. We are talking about bringing down the tension. Okay, so if somebody has won and you are saying that, like this we have today, Nana Addo has not asked the court, you see, EC declared John Mahama winner. Nana Addo could also say that, look, I'm applying for a stay, okay, because you have declared, I don't get it, I'm going to court. For the time being, President Mahama cannot be president. But he says, look, the constitution says you should carry on. You've been declared until a decision is, taken by the Supreme Court. He remains the president. So I don't foresee any confusion, okay, when it comes to the situation whereby he wants to seek a review, should he lose, and say that, look, I want a stay of execution. I want to remain in office until my review application is determined. I cannot foresee that. If anything at all, the Speaker of Parliament may have to act as president until the final determination. But I am of the view that, look, the constitution is clear, and it also depends on the numbers. We are looking at a 9-member panel, and if it is 5-4, and depending on the content of the judgment, the reasoning, if after your lawyers have looked at it and they feel that it was very slim, so maybe 2 additional judges could change the thing. Okay, so let's apply. But it's all subjective. But really, this new the judgment, we have to begin some discussions on it. It's very important so that there would be a smooth transition should Nana Akufo-Addo win. It only becomes an issue of controversy if petitioner should win, but there will be no problem at all. Okay, there will be no problem at all should the status quo remains.
2 scenarios here. Yeah. As far as you're concerned, there's this gentleman agreement that the status quo remains until such time the review is over. But he's also looking at it politically, that once...
I first laid the foundation that gentleman's agreement is not founded in law.
Nobody can enforce it. Nobody can
sure, of course.
It should be enforced.
That's right.
If that he wants to come in, he should be given the chance. That's what you're saying.
Yeah, the Honourable Member of Parliament was belaboring as to the effects of whichever judgment is delivered by the Supreme Court. But I indicated to you the last time, and even before then, that this court is not only a court of law, it is also a political court.
In any case,
and we heard what he said, the last bit, that the best way to secure stability, he used those words, is to say that President Mahama should remain in office.
No, you are misquoting.
Please,
no, what you are quoting,
let's in connection with the fact if it so happens that he wins.
Yes, please.
If you are quoting me,
okay. Say what you said again before I go on.
I am saying that should John Mahama win the case, or should the status quo remain same, it means that we continue with the stability process.
Exactly.
Okay? There's nothing like a stay and all that, because the man is in office. And I cited the example that from the declaration of the result by EC, which is an administrative body, the constitution does not make room for the petitioner to
I think
ask the court to stay.
He has been fairly fair to himself. He has said exactly what he said.
There is an injunction.
He has indicated. Please let me continue. Okay. You have indicated
the very point that I landed on, which you wanted to quote.
No. You're finished.
What you want to quote me?
No. If the court determines in favor of the certain president, as he said, then there's stability. Sure. If not, then all these questions will arise as to whether a review application has to be done. Prior to that, there should be a stay of execution, etc., etc. And that is why I brought back what President Kufuor said in 2002. But this is not only a court of law. It is a court that secures national stability. therefore, in the circumstances, what is the best to secure national stability? In my opinion, and he has hinted at it also, in my opinion, the best way is to retain the president in office. Please.
No. Ambeka, you are going too far.
Please.
For him, he's saying,
I have not finished.
Okay. Well, let's listen to him. We always had opportunity to.
I have not finished. You can always apply for review. So that is when you are talking.
It's prejudicial. No, I understand. Not my day, but I'm saying that no. The discussion here, Henry, let's get it. The discussion is not supposed, because if
all I'm seeking to do is to allow him to finish his line of thought, then you can pick from that.
No, that would be wrong. It is not the discussion. We have discussions that I may have a different opinion. But when the discussion is touching on the very heart of a matter that is still being heard, because then it becomes
take away his right to speak. That's what I'm saying. Let him finish speaking, and then we will obviously come in also. So,
as I said, he hinted at it himself when he said that the proper way to secure stability is to retain the president in office, and that's what I've been saying.
I don't think I heard him.
No, I never said that.
He talks about the best option would be to have the Speaker of Parliament take over. While all those things are
with the greatest respect.
Okay.
What he said was that the way to retain stability, please listen to me very carefully.
Okay. Maybe
the way to retain stability is to keep the president in office. Then this
under what circumstance?
Please.
No, because you are quoting respectfully
of review application.
No, respectfully.
And stay of execution.
That is not being fair.
No, please.
No, you are quoting me, but
please, because
you are from a different party.
Shall I go on? I
think that I also heard otherwise.
Yes.
He thinks that as per what we have now, I mean, the gentleman's arrangement is not founded in law.
Yes,
and so
that's what I said initially. Yes.
Additional wins, then let's hand over to the Speaker of Parliament. That will be a convenient thing. While we
maybe.
Yes.
Maybe
if
that's
But he also used the word stability in a certain context.
Okay.
Harry, you heard
it. Quote me right if you want to quote
that. You heard it.
I used it.
Yes. Why did he use the word stability? Okay. In what context? He said that the way to secure the status quo, indeed, let me use the phrase also he used, the status quo, is to determine that President Mahama has been validly elected.
No, a big no.
Never mind.
No, I would mind.
Okay, never mind. You didn't say it.
Then make your own independent statement.
Let me now state it myself.
State your own point.
Yes,
that's right.
Now state it myself.
State your own
the way to secure stability, in accordance with what I've been saying here for the past 2 weeks or so, is that we should listen to what President Kufuor said.
No.
I have said this here before.
But even you are quoting President Kufuor out of context.
That's right now. I think that
he's quoting President Kufuor out of context. I have the paper here. Uncle, let's read again.
He doesn't want us to talk.
It's a challenge.
He doesn't want me to talk.
Uncle, I want you to talk. Let's read.
No, I will read it.
No. But
I want the paper. I'll read it.
Let me read.
No.
I think it's only fair.
I have not finished my argument.
Because
have I?
You haven't.
Look, but why is he doing this to me?
Entering the tap.
If he doesn't want to talk, you should let me know.
Let's do this thing.
Yes.
Just so that we can have some understanding. Is this supposed to be so heckling of a son? Okay, so you have a right. Read it.
You read it. I will read it. I'll read it.
Let him also read it. And let's see what interpretation.
I don't have any problem with that at all. After all, as long as that's what we do in court all the time. You can see that happening in the Supreme Court case. You understand what I'm saying? I said that the Supreme Court is not only a court of law. I have said this here before.
Yeah, that is a political court.
Yes, it is also a political court. And I said this I said this in support of what President Kufuor said in 2002. And I quoted him directly from March 20, 2002 Daily Graphic, page 3. Please listen. He asked the judiciary not to be concerned with only the interpretation of the law, but should also be mindful of the importance of national stability in making their decision. Continuing, he noted that where judgments are made without due cognizance of their effects on national stability, it could have serious consequences on the nation's democratic process. This is what I said last week, and this is what I'm saying today. I have not departed from the sense that is embedded in this particular thing. So,
what's happening?
So, what I'm saying is that a review may not be necessary if it is 9-0 in favor of John Mahama. A review may also not be necessary if it is in favor of John Mahama, because then the status quo will be continued. That's all I'm saying.
Okay. Okay. So Alex, where do you differ here? You can also take it now.
You know something. Ankaka is not a small boy. He's a lawyer. He's been in practice for over 30 years. Maybe more? 20. Yes, more than 10 years. The first line of argument is not what we are hearing in conclusion, but that's okay. I'll give the same interpretation.
Yeah, so read it.
Sure, why?
Yeah, I've seen it.
Yes.
He asked.
No, hold on.
Exactly.
He asked.
And this.
Yes, that's exactly what
Very
I'm
well.
doing. You showed me the last time.
Very well.
He asked the judiciary not to be concerned with only the interpretation of the law, but should also be mindful of the importance of national stability in making their decisions. I want to end there and say this. That look.
Why do you want to end there? Ask that other one.
You want me to? Okay,
No, because, yes,
okay. He noted that where judgments are made without due cognizance of their effect on national stability, it could have serious consequences on the nation's democratic process.
Has it been quoted out of context?
Oh, per this quote?
Yes.
No, he's not made.
No,
the analysis is made. No, that's okay.
That's okay.
Yes, initially was making an analysis based on this quotation out of context, but later he fell in line.
Okay.
And I agree with him. Now, my interpretation of this is that this infant democracy we are nurturing, we're talking about stability in the context of ensuring fairness, ensuring justice. So I am of the strong opinion, high sense of conviction, that look, if our judges are looking at what is happening, they've looked at the law, if we are going by what Kufuor said, that they should also look at national stability. National stability is not limited to allowing the status quo to remain. National stability also means ensuring justice, ensuring fairness, to the extent that people will have confidence in our state institutions. That look, in an election, if there are some clerical errors, there are some administrative lapses, and those lapses in aggregate affect the results that are declared, justices of the Supreme Court, per what Kufuor said and per what the quotation that the analysis that is being made, you are duty bound.
This was a case where Chachi Chikata.
No. This was a case where he was swearing in.
Yes, but Chachi Chikata had gone to court to declare the fast track high court unconstitutional.
No,
and there was a review.
No,
so he had to appoint additional judges. Isn't it?
Exactly.
Well,
that was the case.
If no,
that was the case here.
I'm coming. You see, when we are quoting and we are trying to analyze out of those quotations, it's very important we tread cautiously. This was an occasion of a swearing in of a Supreme Court judge. Let's leave it there. Don't let us add that it was to seek review and all that. The man was swearing in.
Important to trace the history.
No, you don't have to link it. Let's delink because we are trying to quote why the man was swearing in a Supreme Court judge
who eventually sat
the
on
president.
Case.
Yes, then that one is removed.
So he was needed.
It is not no. I wouldn't want to do the immediate connection. I am saying that,
but would it be fair to detach, to disconnect?
Well, then, if you want to make it broader,
dance around,
Henry,
not really look at the history involved.
Henry,
I think that's what he's been trying to do.
Henry, if we want to make it broader, then we need the full report. Okay,
you don't believe that this is a fair report?
Oh, I've not used fairness yet.
I'm
saying that.
Which report are you talking about?
You see, there was a swearing in ceremony at the castle.
Yes.
And the man was swearing in a Supreme Court judge.
Yes.
And he's reported to have urged him.
Yes.
By urging him, just urging the entire judiciary to not only look at the law, but national stability and all other things.
The government was seeking a review.
No, I am saying that it will be unfair to connect that immediately. Let's treat them independently.
But that's what he's been doing.
Sure, that is his opinion. That is his opinion. I can't take it away from him.
Harry,
I'm not. It's not an issue of comfort. It's also about how I see it.
Okay.
Let's situate it in the context of what the man was doing.
I reckon the two of you will never agree on this.
Certainly, we are coming from two different ideological,
and then arguing that line.
Well, I would want to look at.
I think it's a situation.
Yes, I would, because I am limited myself to the very context that Kufuor made the statement. The reporter did not add that Kufuor also said that
now that they are going to seek review of a decision. At the time that he appointed Afre, did Kufuor say that he was appointing Afre to go and add up to the numbers? The appointment, the selection of judges on a panel is a determination of the Chief Justice. It's not the President. His duty is to appoint. If there's a particular case that the Chief Justice in his wisdom decide to add maybe a newly appointed judge to add to the numbers, that is the decision of the judiciary.
Okay.
So if we connect it, it will be unfair to Kufuor to say that in the context of the statement he made, he was trying to say that, look, Justice Afre was being appointed directly to go and add up to the numbers.
I will
on
give
the
you
Tachuchikata
a minute on this. I've been
case.
hard to go for a break. We'll have to go for a break. But let's quickly on this one, and then you go for a break.
No,
I
think the honorable member of parliament has got it all wrong. I want to ask him just one simple question. Does he agree or does he not agree with President Kufuor's views on the Supreme Court? That's all.
In the context of...
That is all.
In the context
of the Kufuor was not only my president. He was his former party leader. He should tell the whole public whether he agrees with the views.
with him in the context that he put it, not in the context that you are making your analysis.
But it's clear. Two of you will never agree.
Not in the context of your analysis.
Our practice of the law. Our practice of the law depends on precedents. What happened yesterday, we look at those facts and compare them to what happens today. That is how we develop our law.
So for you, we can't detach.
We can't detach what is happening to what happened.
I think that both of you will never agree on this.
But is Kufuor the one who determines those who sit on a matter?
I think that's not what he's actually talking about.
No, it is not.
We'll have to take a break. Honorable. Back. So our continuing coverage of what's going on from court as far as the election petition is concerned. We have still with us PNP for Futu, that's Alex Afenyumakin is here with us, and then also Uncle Kakra Samwa also here with us, joining with the discussion. We'd love to cross over quickly to the Supreme Court area. We have our correspondent standing by, Thomas Adote Papo, who will just give us an idea what's been happening around during this break. Share that with us. We'll come back to the studio.
When this issue was brought up, there were those who did not understand the issues and went to town to shred me and did all manner of things in the social media. I'm sure that the court ruling has clearly vindicated me, and to say that after all, there was something that was done in conflict with our 1992 Constitution, something that we did that was an affront to Article 2 of the 1992 Constitution that I had to bring to court so that it will fall within Article 2. And Article 2 says that any act or any law that is inconsistent with the Constitution, to the extent of the inconsistency, should be declared void. And precisely the Supreme Court has said that some provisions of CI 74 that I brought out are inconsistent with the 1992 Constitution and therefore must be declared void. The declarance of void simply means that I have, like it's said in our national anthem, hold, defended and protected the Constitution of Ghana. And I think that all of us must be looking around to see that right laws are put in place so that they are not in conflict with the supreme law of this nation. But before I proceed, as I keep saying, let me comment the legal team. Before you do that, we're live on television. We are speaking to Bernard Mona, who has just won a landmark ruling with the fact that he came here to challenge CI 74, and that matter is very important to the election petition. Today, the court granted him two of the reliefs that he is seeking. That is whether or not it is unconstitutional for the Chief Justice to set up a court on a public holiday or sit during weekends, and the other one is in respect of the fact that during an election petition and as a ruling, people who are not happy with the decision could seek review. The court said that indeed it is right for persons who are defeated in such matters to seek review. Bernard Mona is here with me and he has more to say. So let me comment the legal team that led by Benson Nichukwu, Ramona Abugabe, and also Joel Ano Afari. they believed in me. They took up the issues and made a legal case out of it. And today, all of us as citizens are going to benefit, including you. Recall that tomorrow you are going to come to the Supreme Court by CI 74 for the judges to sit against the Public Holidays Act that by CI 74 the court was supposed to sit. Tomorrow you can have your holiday if you have any at all. You understand? But many people, including the judges, can enjoy their holiday, and that will not affect the work of any one of us. And I think that it is important that all of us as citizens should be looking at it. The important thing is that in this case, it doesn't matter whether the petitioners win or lose. It doesn't matter whether the respondents win or lose. Any one of them after this still have the opportunity to enjoy the fullest of their legal entitlement, including a review, so they can come to the Supreme Court to seek a review. And the Supreme Court says, look, even the Supreme Court, they can sit down to look at their own cases and realize that no, maybe they did not look at certain aspects of the law, they did not factor certain essential elements before they took a certain decision, and therefore they can review that decision. So for any subordinate law to come and say that you cannot seek a review in a presidential election petition, it means that that subordinate law is overstepping its bounds, and therefore the rules of court committee cannot apply in this particular matter. And I think that it is positive news for us. The important thing is that public holidays, and if you take CI 74, it says that look, the judiciary must sit when there is a presidential election petition, must sit daily, including Saturdays, Sundays, and public holidays. My contention was on the public holidays, not even the Saturday and Sunday. Public holidays include our Independence Day. So if on 6th March there is a presidential election petition, for instance, the judiciary will be compelled to come and sit because there is a CI 74. Meanwhile, we know that our Independence Day is the day that granted us the freedom so that we can have a nation in which we should have a judiciary, a nation in which we can be independent of our own, can even conduct elections. Without that day, we will not exist as a nation, let alone celebrating a day. You understand?
Bernard, I understand your point, but indeed there are those who are of the opinion that this will give a lot of powers to the president, and when it comes to separation of powers, there's some inconsistencies here, because indeed it is only the president who can ask for a public holiday. Don't you think that too much power is being allocated to the president?
I don't know where that separation of powers thing is coming from. I'm not sure that you are advocating for a watertight separation of power.
Not at all.
If you are not advocating, why? It is the same president that take the judges that go to parliament. You remember, for the parliament to vet the judges and come back for president to endorse them, and yet the judges are supposed to be independent. It is the same president that appoints the chief justice, that is the head of the judiciary. And where are we talking about separation of powers here? What is important is that we have to uphold, defend, and protect the Constitution of Ghana. And that is what we have done. That there are laws that are inconsistent with the Constitution that I have found, that any other Ghanaian could have found. But I brought the matter for the Supreme Court to do interpretation. And the Supreme Court has vindicated my position that I was right.
Thank you very much. Bernard Mona is with the PNC, and today the Supreme Court has upheld a very important matter, and it appears that he has been vindicated in the fact that he brought the matter to court. So as it appears now, it is not possible for us to come tomorrow being May Day and a public holiday. So Henry, if you're listening to me, it is clear that the court cannot sit on a public holiday. Neither can it bar any person seeking a review from doing that. So clearly, tomorrow we might not come to the Supreme Court hearing for the petition. If it happened, it will be